Contracts. Identification and interpretation. Clarifying the terms of contracts. Contracts. Identification and interpretation. Clarifying the terms of contracts. Having decided that a contract was formed, the court often has some work to do to determine all the provisions. Obviously, a written countersigned agreement is a good starting point. But the court is often forced to look outside of the four corners of this document when collating all the terms. Other writings can be incorporated into the contract. For example, the contract may refer to a price list that's published elsewhere. The UCC provides a gap-filling role when the contract deals with the sale of goods. A contract for the sale of goods could be as short as, "Please send me 30. The UCC will fill all the gaps in the contract. The common law fills gaps in contracts for services and non-goods, but it requires a more substantial starting point. "Please send me 30 would be insufficient to form a contract under the common law, as the material terms such as identity of the parties and price are missing. Conduct of the parties, what they do, will sometimes be considered by the court when determining these terms. A written document does not always represent the deal that the parties consider final. The writing may, for instance, be intended only as a tentative draft of their agreement. If the parties do intend a document to represent their final expression of the agreement, the document is said to be an integration. If the document is not intended to include all the details of the agreement, it's said to be a partial integration. If the document is intended by the parties to include all the details of the agreement, it's called a total integration. The courts are often presented with cases where the parties claim a verbal agreement displaces terms of a written contract. In dealing with these situations, the courts apply what's called the Parole Evidence Rule. Under the Parole Evidence Rule, the writing trumps anything that was said or negotiated before the writing was created. Parole evidence does not apply to evidence that appears after the writing was formed. These will be addressed as modifications. The general rule is that the writing trumps all prior discussions. There are, of course, exceptions that allow other evidence to be admitted to the court in order to help the court determine the terms of the contract. The first exception applies where the writing was a mistake and did not accurately evidence the agreement. The writing contained a typo or clerical mistake. The second exception applies where the contract is questioned on grounds it was agreed under conditions of misrepresentation, fraud, or duress. The third exception allows verbal and other evidence where it is necessary and helpful in explaining terms of the written agreement. Of course, this is most common where the written terms are vague and ambiguous. The fourth exception to the general rule that the courts admit evidence outside the written agreement is where the writing is incomplete, where there are missing terms, and these terms would naturally and normally be provided in a separate agreement or a separate document. The court will allow additional evidence to supplement the written agreement. Yes, it says blue in the written agreement, but when the buyer called me, I agreed on the phone to change the color to green. Where a case involves non-written information being incorporated into a written contract, it raises at least two issues. Firstly, the court must apply the statute of frauds to see if a written amendment was necessary and if the new terms are unenforceable in its absence. Secondly, the court assesses whether the writing was a complete representation of the agreement and whether parole evidence is restricted under the terms of the contract. Parole evidence and statute of fraud rules are often seen in the same cases. There are several rules for interpreting the meaning of ambiguous contractual terms. Generally, an ambiguous term will be construed against the person that drafted the contract. Evidence of custom may be admitted to show that the parties intended for the contract term to have a particular meaning. Sources of custom include the course of performance, which means how the parties have interpreted that term during the life of the present contract; course of dealing, which deals with how the parties have interpreted the same term in contracts between themselves in the past; and trade usage, the meaning attached to terms within a particular industry. Where the term is omitted, the court may fill the gap, supplying a term after taking guidance from the UCC or the common law. What the parties do, as well as what they say and what they write, can have a bearing on the terms of the contract. The courts are most persuaded by the conduct of the parties to the contract in performance of the contract. So if an offer is made by a party who subsequently performs the duties specified in the offer, and the other party fails to accept, but also fails to object when performance is being carried out, then the acquiescence of the second party is relevant to determining if a contract was formed. Courts are somewhat less persuaded by the conduct of these parties in other dealings. Course of dealing is a clearly recognizable pattern of previous conduct between parties to a business transaction, and this will often be considered by the courts to identify and interpret the contract. Courts are least persuaded by the customs and conduct of other parties in similar contracts. For example, the customs and usages of the trade can be used to define when an offer lapses. If it's customary for acceptances or rejections to take place within 24 hours of the offer, then it would be reasonable for the court to find that an offer in such an industry would lapse after 24 hours. Conduct of the parties and other similar parties in similar situations can be used by the court to determine the existence and terms of a contract. The UCC provides an extensive gap-filling role in contracts when we're dealing with the sale of goods. When selling goods, your contract can be very small. In fact, the only term necessary is the quantity of goods to be sold. All the other terms can be filled in by the UCC. Where a contract for the sale of goods is silent on a term, the UCC will be used to fill the silence. Sales of goods involve some form of delivery. There are basically two types of performance when it comes to delivery: delivering to the customer or delivering to the shipper. These are known as shipment or destination contracts. It's important to know what type of delivery is required when entering into a contract requiring delivery. The most common is a shipment contract. The duties of the seller here are performed when the goods have been placed FOB, freight on board, a common carrier, such as the UPS. Who bears the loss in a contract for the sale of goods when the goods are lost or damaged en route? Firstly, if there's an agreement covering the risk of loss, then this controls. Secondly, the breaching party is liable, regardless of the type of breach. When the court can find any form of breach, the risk of loss will be assigned to them. Thirdly, the risk of loss shifts from the seller to the buyer when the seller completes his delivery obligations. So if the seller is obligated to deliver to the common carrier under a shipment contract, then the loss or damage affecting the goods after this point are borne by the buyer. If there's no agreement regarding loss, there's no breach and no delivery to a common carrier. The risk of loss rests with the seller if the seller is a merchant. If the seller is not a merchant and no common carrier is involved, we drop down to number 5, where the buyer bears the risk of loss after the goods are tendered by the seller. Tender is the point at which the seller makes the goods available to the buyer. Promises are often made by sellers to prospective buyers, and the question before the court in a contract dispute is whether the promise forms a warranty that becomes a significant provision in the contract. Some dialogue between buyer and seller is not taken seriously by the court. A statement that the goods are of high quality would be considered as mere puffery and would not qualify as a contractual obligation. However, a statement that the goods are made of unbreakable titanium is more specific and would likely be considered a warranty that's part of the contract. The question of when the statement was made becomes a factor in these cases, as statements made prior to the written contract being formed are generally excluded as evidence. Under the Parole Evidence Rule, the writing is assumed to include all the promises made by the parties up to that point. Showing a sample or a model of the product to be sold creates a warranty that the product delivered under the contract will have similar features and quality to the sample. Although the sample may be shown without any express words of warranty, the sample is deemed an express rather than an implied warranty. Showing the sample was an expression of warranty. Implied warranties are implied by operation of law. Statutes derived from the UCC impose a quality obligation to protect consumers. For example, when a merchant sells a good, a warranty is supplied by law. Although there may be no written or verbal warranty or even a sample, a merchant-sold good carries a warranty of merchantability. Breach of contract results if a good sold by a merchant is not of merchantable quality. Merchantable quality means fit for the ordinary purpose. A raincoat may be of merchantable quality for dealing with a regular shower, but it would not be suitable for a climb to the top of Mount Everest. Climbing mountains is not an ordinary purpose for a raincoat. The warranty of merchantability applies when the merchant is selling goods as a business. A merchant in the business of selling luggage is obliged by the UCC to ensure all the luggage she sells is of merchantable quality. However, if she then sells her own personal TV, this carries no such warranty, as she's undertaking the transaction as an individual, not as a merchant. She doesn't sell TVs for a business, so she's not a merchant in this situation. As well as a warranty of merchantability, the law also provides a warranty that the goods are fit for the purpose intended. This does not attach to all goods, but to situations where the buyer tells the seller of the purpose, the seller selects a product suitable for the purpose, and the buyer relies on the seller's selection. In our case of the raincoat, this warranty would attach if the buyer informed the seller of the expedition to climb Everest. The seller told the buyer that the raincoat would be the ideal garment for such a journey. The buyer believed the seller, purchased the raincoat, and proceeded to climb Mount Everest in it. The raincoat did not breach the warranty of merchantability, as it was fit for the ordinary purpose of dealing with rain showers. But the coat was not fit for climbing Everest, as the merchant had promised. So this sale breached the implied warranty that it was fit for the purpose intended. If you buy a car with cash and it proves to be defective, can you return the car to the dealership? Generally the answer is yes. If the defective car was leased, can you stop making the lease payments? The answer here depends on whether you lease the car from the dealer or you make your lease payments to a bank or finance company. The warranty of merchantability is effective against the car dealer, the merchant, but is not effective against a finance company, even though the finance was provided in relation to the car. If the contract for sale of goods contains both express warranties and a disclaimer of warranties, as many do, which one wins? Does the warranty exist, or is it disclaimed? The answer is that the express warranty trumps the disclaimer. The law protects the consumer from the contract that highlights product claims and warranties, but then inserts a small disclaimer in the back of the document that would render the warranties void. The consumer wins, and the warranty is held to be part of the contract, disclaimer or no disclaimer. The words sold as is, with all faults or similar conspicuous language, can, however, prevent the implied warranty of merchantability attaching to a sale of goods. Even if the product doesn't work at all, the sale is final and a refund cannot be provided by the court, as the implied warranty was disclaimed. Can the merchant selling goods restrict the type of remedies that are available to the buyer for breach of contract? The general answer is yes. If the sale contract states that there are no cash refunds and the only remedy available to the buyer is a replacement product, the UCC and the courts will support the merchant's position and restrict the buyer from receiving a cash refund. The exception is where the limitation of remedies is unconscionable. This is not as small an exception as you might think, as all situations where the merchant restricts the remedies for personal injury cases are presumed unconscionable. So if a merchant sells a good under a contract that states the buyer's only remedy is a replacement product, and the product then explodes, causing personal injury, the UCC will support the buyer's claim and the remedy of a replacement product would be deemed unconscionable by the court.